Your phone is in your pocket right now, and right now it's broadcasting. Not because you have anything open, not because you're on a call or running an app, just because that's what phones do. They look for networks, they register with cell towers, they emit small signals as part of their normal, constant background operation. None of that is a secret. It's just how cellular technology works. It's been working this way since the beginning of mobile phones. What has changed, and changed significantly, and is still changing, is the legal framework around who can access the data that those broadcasts generate. What's legally accessible, under what process, with what level of judicial oversight. And what hasn't kept pace with the technology is most people's understanding of where those lines actually are. That gap between the data landscape people think they live in and the one that actually exists is what this video is about. Not paranoia, not they're watching you. Just an honest, accurate, documented explanation of what information your phone generates, who can seek access to it, and how, and what legal protections currently exist, including where they're strong, where they're genuinely underdeveloped, and where courts are still working out the answers. Because understanding this isn't about being afraid, it's about being informed in the world you actually live in. Let's start with the most foundational piece. In 2018, the Supreme Court issued a landmark ruling in Carpenter v. United States. The case involved whether accessing historical cell site location information, the data your phone generates as it connects to cell towers throughout the day, requires a warrant. The court said yes. By a 5-4 margin, the court held that accessing this kind of detailed historical location data requires a warrant supported by probable cause. The ruling was significant because it represented a departure from the third-party doctrine, the long-standing principle that information voluntarily shared with third parties receives reduced Fourth Amendment protection. The court recognized something that prior doctrine hadn't fully confronted. When you carry a phone, you're not voluntarily providing your location to your carrier the way you might voluntarily share information with a person. You're just living your life, and the data is generated as a byproduct. The comprehensiveness of that data, able to reconstruct your movements over months or years, placed it in a category that warranted stronger protection. Carpenter was a meaningful ruling. It established that, for historical cell site location information, law enforcement generally needs a warrant. But Carpenter also has limits, and understanding those limits is as important as understanding the ruling itself, what Carpenter doesn't fully cover. The ruling addressed historical cell site location information specifically. It didn't resolve the full range of questions about what other kinds of phone-generated data require warrants. Real-time location tracking, metadata about communications rather than content, data obtained from third parties who collected it for commercial purposes. Different courts have reached different conclusions about how Carpenter's reasoning extends to these situations, and the legal landscape is genuinely unsettled in some areas. This is not a conspiracy. It's a legal system catching up to technology that moves faster than legislation and litigation. The questions are being worked out in courts across the country. Some have been resolved in some jurisdictions, others haven't. What this means practically: the legal protection on your phone's location data is stronger than it was before 2018. It's also not uniform, not complete, and not fully settled. Let me explain a few specific methods that are documented, reported on, and publicly known, because this is where most people's knowledge has gaps. Cell site simulators, sometimes called IMSI catchers, sometimes referred to by brand names that have become genericized in public discussion. These are devices that mimic a cell tower, causing nearby phones to connect to them instead of a legitimate carrier. When a phone connects, the device can capture identifying information about that phone, and, depending on the sophistication of the device, potentially more. These are real. They've been documented through public records requests, litigation, and investigative reporting. Law enforcement agencies at various levels have used them. The legal framework around their use varies significantly by jurisdiction. Some states have passed laws requiring warrants for their use. Some federal agencies have policies requiring judicial authorization. In other jurisdictions, the requirements are less clear. This is an area where legal protections are genuinely inconsistent across the country. If you've ever been in a public space during a large event, a protest, or a situation involving a significant law enforcement presence, and your phone behaved oddly, lost signal unexpectedly, or dropped to a slower network, the presence of one of these devices may have been a factor. Or it may not have been. The point isn't to create anxiety about every dropped call. The point is that this technology exists, its use is documented, and the legal framework around it is still developing. Geofence warrants. This is newer and involves a different mechanism. Rather than tracking a specific individual's phone, a geofence warrant asks a tech company, most commonly Google, through its Sensor Vault location database, to provide the device identifiers of all devices that were in a specific geographic area during a specific time window. If you were in a particular location when something happened there, even as a completely uninvolved bystander, your device identifier might appear in the results of a geofence warrant. From that, investigators may narrow down the identifiers and seek identifying information for specific devices. This practice has been reported extensively and has become the subject of active legal challenges. Several courts have found significant Fourth Amendment concerns with geofence warrants. Some have found them unconstitutional on their face. The legal landscape here is genuinely in flux. Google has made changes to how it handles location data that may affect the availability of this information going forward. But understanding that this mechanism exists and has been used is part of the accurate picture. Commercial location data. This one is perhaps the least understood of all. Your phone's location data doesn't only exist with your carrier and the major tech platforms. It also flows, often without clear disclosure, to an ecosystem of data brokers who aggregate it and sell it. App permissions that seem unrelated to location sometimes include it. The commercial location data market is substantial. Law enforcement agencies have, in documented cases, purchased commercially available location data rather than seeking it through legal process. The rationale is that data voluntarily shared with commercial entities and available for purchase doesn't require the same judicial process as other location data access. Courts and legislators are actively grappling with this. Some have held that even commercially purchased data requires judicial authorization under certain circumstances. Some jurisdictions have passed legislation restricting this practice. Others haven't yet addressed it. This is not a claim that you're being tracked. It's an accurate description of a documented practice with an evolving legal framework around it. Let's talk about what you can actually do with this information. The first practical step: understand what location services and permissions are active on your phone. Most phones have granular controls over which applications can access location data, all the time, only when in use, or not at all. Reviewing and adjusting those permissions is something you can do right now, in your settings. This doesn't eliminate location data entirely. Your phone's connection to cell towers generates some location information regardless of app permissions, but it substantially limits the commercial data ecosystem's access. The second, understand what you're agreeing to when you accept terms of service for apps and platforms. Most people don't read these. The location sharing that happens as a result of these agreements is part of how commercial location data gets generated. Third, for situations where location privacy matters specifically, and there are legitimate personal reasons someone might want this, completely unrelated to anything unlawful, devices have airplane mode. It disconnects from cellular networks entirely. Some people use this during sensitive personal situations for reasons that have nothing to do with law enforcement. None of these are about evading investigation. They're about understanding what your devices generate and making informed choices about it. What if you learned that your location data was accessed without your knowledge? This is the situation most people have never thought through. If law enforcement accessed your location data through proper legal process, a warrant, a court order, an appropriate legal mechanism, that access was lawful. The existence of the access doesn't mean anything illegal happened, to them or to you. If you have reason to believe data was accessed without appropriate legal process, if you've been made aware of it through legal proceedings or other means, that's a situation for an attorney who handles Fourth Amendment and privacy issues. The legal challenges to some of these practices are real and ongoing, and individuals who've been affected by legally questionable data access have sought remedies through courts. The broader picture. If you're ever in a legal situation where location data is relevant, where someone is placing you at a specific location at a specific time based on phone data, an attorney can challenge the collection method, the legal authority for collection, and the accuracy of the data interpretation. These are legitimate legal challenges. They've produced results in some cases. Let's run through scenarios quickly. What if you're asked during any encounter about your location at a specific time? I'd prefer not to answer questions without speaking to an attorney first. Same phrase that applies everywhere. What's on your phone and what your phone records might show are different things, but your verbal response to location questions carries its own legal weight. What if your phone shows you were somewhere you weren't? A data interpretation error? Phone location data is not perfectly accurate. Cell tower triangulation has a margin of error that can range from hundreds of meters to miles, depending on tower density and conditions. GPS app data is more precise, but has its own accuracy variables. Data that appears to show your location is interpretive, not definitive. Attorneys who handle these matters understand how to challenge the accuracy and interpretation of location evidence. What if you receive some kind of notice that your data was requested? Some platforms notify users when their data is requested through legal process. Others don't, especially if a gag order prohibits it. If you do receive such a notice, that's the moment to contact an attorney, not to do anything to change the situation retroactively, but to understand what it means and what options exist. What if you want to be more intentional about location privacy going forward? Review your app permissions. Be thoughtful about which apps you grant location access to. Understand what background location access means and whether it's necessary for the apps you use. Use airplane mode in situations where location privacy matters to you personally. None of this is about anything improper. It's just being informed and intentional about what your devices generate. Here's what I want you to take away. The data landscape around your phone is more complex than most people realize. Some of what exists is strongly protected. The Carpenter ruling was a meaningful step. Some of it is still being figured out. Geofence warrants, commercial data purchases, cell site simulators in jurisdictions without clear warrant requirements. Understanding this isn't about being afraid, it's about being accurate. The world you're living in generates data about you in ways that weren't true 20 years ago. The legal system is working to catch up. In some areas it has, in others it's still working. That working it out process is happening in courts, in legislatures, through litigation brought by people who understand their rights and know how to challenge what might be improper. Being informed enough to know when something might warrant that kind of challenge, or to understand what's being discussed when it comes up in your situation, that's what this video is for. Now, here's where I want to point your thinking before the next video. We've been talking about data your phone generates passively, just by existing, just by connecting to networks, just by running, and the legal framework around accessing that data. But there's a different category, not data your phone generates without your involvement, data you create, messages, calls, emails, the actual content of what you communicate. The legal framework around accessing the content of communications is different from location data, stronger in some ways, more complex in others. And the circumstances under which your private communications can be accessed, with or without your knowledge, is something that touches almost everyone who uses a phone or computer. That's what comes next.